Be ready. Start. This court in state of T.N. and another versus P. Krishnamurthy and others held that a subordinate legislation can be challenged on the following grounds. Stop. Lack of legislative competence to make the subordinate legislation. Stop. Violation of fundamental rights guaranteed under the Constitution of India. Stop. Violation of any provision of the Constitution of India. Stop. Failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the enabling act. Stop. Repugnancy to the laws of the land, that is, any enactment. Stop. Manifest arbitrariness, unreasonableness to an extent where court might well say that legislature never intend to give authority to make such rules. Stop. It is relevant to examine whether a subordinate legislation can be declared as unconstitutional on the principle of proportionality. Stop. The challenge to the order dated 7th August 2004, by which the respondents were deprived of an opportunity of being considered for employment, is on the ground of violation of Articles 14, 19 and 21 of the Constitution of India. Stop. Lord Diplock in Council of Civil Service Unions versus Minister for the Civil Service held that the interference with an administrative action could be on the grounds of illegality, irrationality and procedural impropriety. Stop. He was of the opinion that proportionality could be an additional ground of review in the future. Stop. Interference with an administrative decision by applying the Wensbury principles is restricted only to decisions which are outrageous in their defiance of logic or of accepted moral standards, that no sensible person who applied his mind to the question to be decided could have arrived at it. Stop. In Om Kumar and others versus Union of India, this court observed that the principle of proportionality was being applied to legislative action in India since 1950. Stop. Any challenge to restrictions imposed by the government under Articles 19 are tested by courts on the principle of proportionality. Stop. Whether restrictions placed are reasonable or not is adjudicated on the basis of appropriate balance between rights guaranteed and the control permissible under Article 19. Stop. When legislation is challenged on the ground that restrictions placed on the fundamental right is disproportionate, the courts conducts a primary review where the state has to justify the necessity of restricting the fundamental rights. Stop. Proportionality involves balancing test and necessity test. Stop. The balancing test relates to scrutiny of excessive onerous penalties or infringement of rights or interest of and a manifest imbalance of relevant considerations. Stop. Whereas the necessity test requires infringement of human rights in question to be by the least restrictive alternative. Stop. According to Aaron Barak, proportionality in the broad sense is based on two principal components. Stop. The first is legality which requires that the limitation be prescribed by law. Stop.